Hi, Attorney Steve Vondran, the real estate lawyer, and we are back. We are talking landlord-tenant law, real estate agents, the ability to try to earn a commission on the weekends when you have a tenant living in the property. So we can call this another episode of Commission College. And we're going to go to the Attorney Steve whiteboard, and we're going to talk about earning that commission when you have a tenant in the property. You have a landlord that wants to sell the property, but the tenant doesn't want to be bugged. The tenant says, well, I have rent control statutes, or I have the right to quiet use and enjoyment of my property under the lease. And so the question becomes, well, the landlord wants to sell. He wants to get some tenants or some prospective buyers in there on the weekend. They want to have an open house. And so the seller, he or she, wants to hire an agent to come and help them market the property, but the tenant's being stubborn. What do you do? So this is one of those cases. So let's go to the real estate whiteboard. Okay, so we are talking in this case Dromy versus Lukovsky. Dromy versus Lukovsky. This is a case out of the Court of Appeals in California, 2nd District in Los Angeles. Real exciting case. Let's talk about it. Okay, so Dromy is the landlord. Dromy here owns the property. And as I point out here, property is alienable. It's one of the things, if you remember from your real estate exam, the alienability, the right to transfer and sell your property to another person. So property is freely alienable. So Dromy, the landlord, owns a condominium out in Santa Monica. The tenant is Marina Lukovsky. Marina Lukovsky is the defendant in this action. She's a tenant. Seeking quiet use and enjoyment of her property. And as you know from real estate law, every tenant has the right to reasonably enjoy and possess real property and to be free from an intrusive landlord that wants to come in and harass and do these kinds of things. So realize in every legal case there's these competing interests that are going on, and that's what's going on in this case, okay? So the landlord hires the agent, Daphne Milstein, that's Daphne Milstein, to be the real estate agent, and the real estate agent wants access to the property. Well, the tenant says, well, wait a second, we have a statute in California, the Civil Code, Section 1954, California Civil Code Section 1954, that says that a landlord may only enter the premises under certain specified conditions. We have it in the law here. 1, in case of emergency. 2, to make necessary or agreed repairs. 3, when the tenant has abandoned or surrendered the premises. Or 4, pursuant to a court order. Okay? So, as it goes on to say, Section 1954, except in cases of an emergency or when the tenant has abandoned or surrendered the premises, entry may not be made during other than normal business hours. Other than during normal business hours. So the tenant was arguing, well, wait a second, you want to come show open houses on the weekends? I just want to relax, turn on the tube, watch some TV, you know, play with my friends and pets, and you are coming in here trying to sell my property. And the tenant also noted that certain things had been disturbed, certain items of physical possession had been disturbed. So they're like, no, that this isn't reasonable. So what happened is the tenant, the landlord who wanted to sell the property, got a declaration from the agent who said normal business practices in the real estate business requires that houses be shown on the weekends like an open house. That's when everybody does it. That's when people are free to shop with their spouses. So we need this reasonable access, and this should be construed as a normal business hour for real estate agents. This is when agents routinely show these properties. Okay, so at issue was the California Civil Code Section 1954. You can look that up on our website, vondranlegal.com. You can find out more information there if you want to read the actual text of the statute. So Dromy has their agent. The agent gives them a declaration. The tenant doesn't want to budge. So the plaintiff, Dromy, ends up filing what we call an action or a complaint for declaratory relief. Now what's that? Well, that's where you're not necessarily, you're not necessarily suing for damages. You're suing for the court to make a determination as to your rights and obligations under the lease, in this case the terms of the lease. So the owner is coming to the court saying, hey, I'm trying to show my property, I'm trying to sell it, we're trying to do this during reasonable hours, and I just need a declaration as to what my rights are under California Civil Code Section 1954. So that's what the case was about. So they filed this under CCP 1060, and I'll read that for you real quick. That's the Code of Civil Procedure. Basically says any person interested under a written instrument, in this case the lease, excluding a will or a trust or under a contract, or who desires a declaration of his or her rights or duties with respect to another, or with respect to, in, over, or upon property, or with respect to, okay, anyway, point is, you can go seek a declaration as to your rights and obligations under the lease. Okay, so that's what's going on here. He files the declaratory relief action. He eventually files a motion for summary judgment. We've talked about that in other videos and blogs, what a motion for summary judgment is. Ultimately, he gets the judge to make a order. This was one of the things we talked about under CCP 1954. He gets an order from the judge saying, yes, you may enter the premises under you can do open houses twice per month from 1 o'clock to 4:30 p.m. So it was a very limited time frame. 1 o'clock to 4:30 p.m., limited business hours. And also on the weekend would also be a possibility that the court would require that the landlord or the agent, the real estate agent, would reach out, would provide 10 days written notice by email of when they intended to hold the open house on the weekends, so that the tenant could get prepared. Okay, and so the 10-day written notice, and the court ordered that the tenant be required to respond to that 10-day notice with some sort of confirmation of yes on the dates or no on the dates, or providing alternative dates within 48 hours. So the court put in place this mechanism to try to balance the interests of the parties, to try to balance the quiet use and enjoyment of the tenant, and to the free right of alienability or transferability of the property. So this is what's going on. Obviously the landlord needs to get in to be able to sell. Obviously the tenant wants a little privacy, wants a little bit of reasonableness in the process. So that's really how this case down. A couple takeaways. The landlord can show the property with reasonable notice in California. Reasonable notice. Try to work with the tenant and landlord and the agent need to try to work together in a reasonable fashion, because you don't really want to have to spend the money to come to court to do a motion for a complaint for declaratory relief. You'd rather just work it out amicably, save some money if you can. But in this case, the court ordered that the agent be present with the landlord, because the tenant was concerned about personal things being rummaged through and things that seemed out of place, and an invasion of privacy to a certain degree. So the court ordered that the agent be present there with the landlord. The court looked to the Uniform Residential Landlord-Tenant Act. It's another thing the courts may look to. The Uniform Residential Tenant Act looks like ULTRA, but it's really URLTA. And so to interpret this section in making this finding that reasonable hours, normal business hours, that this was all acceptable in looking at the legislative history of the law. So that's a quick rundown of landlord-tenant rights when you're looking at trying to make your commission as your broker, trying to make that commission so you can get the deal, trying to stay out of court, trying to balance the rights of the parties. Remember, in a landlord-tenant situation, if you're harassing or doing things to the tenant, you could be committing a constructive eviction. And that's, you know, where you're effectively evicting somebody because you're intruding so egregiously on the quiet use and enjoyment. So bear that in mind. Be careful on that. Attorney Steve Vonner, we are a real estate and business law firm. We litigate. We help you in arbitration cases. We help real estate brokers and agents in their commission disputes. And we can help you if you have a problem. So don't forget to subscribe to our channel so you can get these great videos coming back to you every day. And other than that, go out there. It's a great day in the real estate business. We look forward to working with you. Thanks a lot.